Yeah, I just got here. It's 3:06. I got here about 5 minutes ago. Yes. And I was going through the service of the order. Yes. Unless the respondent's lawyer was present at the hearing, this order must be served on the respondent. Yeah. The respondent must know what restraint provisions are in place and when the order expires. Oh. Now, you may choose service by a law enforcement agency, a hired professional process server, another person 18 or over who is not party to this action, mail, or publication. If the judge previously entered an order allowing service by mail or publication. Yeah. If you want law enforcement to serve the order, check that box. You must identify the police or sheriff's agency where the respondent lives or works. Yes. If the respondent's service address is within city limits, name the city police. If the respondent's service address is outside of city limits, name the county sheriff. Now, if you have an order allowing service by mail or publication, check that box and specify which type of service. You're making private arrangements for service of this order, check that box. Private arrangements include a hired professional process server. Another person 18 or over who is not a party to this action. If the respondent or the respondent's attorney appeared at the hearing, check that box. Yeah. Now, you will need to provide an address where the respondent can be located for service. This could be a home or work address. If you do not have a service address for the respondent, contact the clerk or advocate for information. Oh. Now, law enforcement assistance. Yes, the judge can order law enforcement to assist you in limited ways. If you still need assistance from law enforcement, check the same boxes you checked in the petition. Yeah. If you have any question about this order, ask the court clerk, the courthouse facilitator, yes, or the domestic violence advocate. Then sign the form. The judge will fill in the date and time the order was granted and sign his or her name. Page 3 or 4, and then it's sign the bottom of the form where it says presented by and petitioner, include today's date. The respondent will sign the form if the respondent comes to the hearing and no further service is necessary. Now it says here, sign the form. Yes. And then it says here, sign the bottom of the form. Yes. Presented by petitioner. Today's date. Now, I was just looking at the exhibit A, where there is no county, and there's no county. Says sign the form. Yeah, and it says that. It says sign the form right there, and then put today's date. Yes. Now I know these instructions, the DVI 3.015, where it says sign the form. Yes. The judge will fill in the date and time the order was granted and sign his or her name. Now, this would be Commissioner Brent Baisden. Yes. Dated 7/31 of 2015, 2:05 a.m. No, p.m. Yes. And then it says, sign the bottom of the form where it says petitioner. Presented by and petitioner. Yes. Now it says here, I acknowledge receipt of a copy of this order, and then you sign the form. Yes. Now I had read that my public defender had a meeting with the mental health evaluator. Yes. And for some reason, they gave her a chance to sign it, but it says sign the form. It says sign the form. Yesterday we talked about the judge proof forms of the state of Washington. Yeah. Revises and goes through draftings of, and there was even some thought that after certain cases, they have to revisit their actual design of the form. Yes. Seems that some judges don't believe the imperceptible idea that you could be using forms that the judges. Now, there's probably a problem with instructions. Okay. Why don't you give me the instructions on every state court website? Yes. On how to fill out the forms, because it's obvious that you don't know how to read. Now, there's something I'm going to sue you about today, okay? This says here, you need to provide this could be home address if you do not have service address, if there's respondent, so on and so forth, professional. Law enforcement service, check that box, you must identify, yes. The respondent must know, I already mentioned that as a lawsuit, yes. Unless this order must be served on the respondent, yeah. Now, order you will assistance. If you have any questions, wait a second. I just read it. Now, let me see here. It says, unless the respondent or the respondent's lawyer was present at the hearing, this order must be served on the respondent. Respondent must know the restraint provisions are in place when the order expires, and you would say it expires in 2025. Ooch. Is there actually some sort of provision? Now, if you want law enforcement to serve the order, check that box. You must identify. If the respondent service address is within city limits, name the city police. Yeah. If you have an order allowing service by mail, check that box. If you are making private arrangements for service, check that box. Yes. You will need to provide, if you do not have a service address, contact the clerk. The judge can order law enforcement. Ask the court clerk. Yes. Wait a second here. The respondent must know you may choose service by. Well, you must identify. If you have an order service by mail, check that box. Yes. Making private arrangements for service of the order. Not a party to this act, the respondent's attorney appeared to check that box. If the respondent or the respondent's attorney appeared at the hearing, check that box. Is that where you say that the respondent was or was not present at the hearing? Yes. But it looks like it should be on a different page. Hang on just a second here. Now, treatment and counseling. Hang on just a second. I'm just looking here. It must be on page 4 or 6. No. You remember this yesterday where the respondent did not receive actual notice of it? Yes. But you're supposed to check the box that says, hang on I can't find it. I've got so many court orders. No, you just wouldn't remove it, would you? Because you're being dicks. And you're really pissing me off because I went through so many different emails today and somebody said, well, Gmail had upgraded all their accounts so that when you receive an email that has, wait a second here, pictures in it, they automatically deleted it. Petition served by mail, publication, make private arrangements. Respondent appeared and was informed of the order by the court. Further service not necessary. Now, let's say that you didn't give the respondent notice. Yes, because that's what it says. Received actual notice. Well, when you did not actually mark on page 1, a respondent was or was not present, it's not the lawful use of the service to not identify if the respondent was or was not. I would say it's a wrongful execution of the order because unless you actually mark one of those two boxes, yes, was or was not present, you actually can't mark this box that the respondent did appear and was informed of the order by the court. See, sometimes they confuse you. They'll put one where it says was or was not there. It's a difficult time when I understand you're commissioner. But they have these boxes, and the instructions say, well, check this and check that and check this. Yes. And it's kind of difficult to know, okay. Was the respondent living in Port Angeles, Washington, or was it the sheriff that should have served them? Was it a wrongful execution of the order when you served me in Sequim, Washington? True. Now, there are sheriffs in Sequim, but I don't think it was a sheriff that served me in the Sequim Public Library. No. But see, the problem is if you don't mark one of these two was or was not present, you cannot legally mark respondent appeared and was informed of the order by the court. Yes. See, you could have said I was there when I wasn't there, and then you could have said that I actually did appear in court when I didn't appear in court.